This case is a powerful example of what happens when second chances turn into repeated patterns. We're looking at a defendant with a decades-long criminal history, stretching all the way back to the early 1980s, now standing in court again for theft, but this time facing serious consequences due to prior convictions. The court already offered a deal, even capped the sentence at 6 years. But here's the real twist. The judge isn't just deciding punishment. He's deciding whether this is someone who
obviously
can
know where children come from, right? And you make the decision to get pregnant again. Well, I mean, but you know how you get pregnant. You know how not to get pregnant.
Judge,
This is where the tone of the courtroom starts to shift. The prosecutor openly questions whether the defendant can be trusted at her word, and that's huge. In sentencing hearings, credibility matters just as much as the facts. If the court believes the defendant is being honest and sincere, it can influence leniency. But when there's a long criminal history involved, especially repeated offenses of the same type, that trust starts to erode. The judge is now balancing empathy against evidence.
Bipolar, anxiety. That's the main issues that are not.
It does mention that in the interview, actually. Under the part that says interview with defendant, it mentions those things. Anything?
And as well, I think it's mentioned in Dr. Gertman's report as well.
Sure. All right. Any other corrections or objections or additions to the report?
No.
The defense is taking a bold approach here, asking for probation again despite admitting it hasn't worked in the past. That's a tough sell. Probation is designed as an opportunity for rehabilitation outside prison, but when someone repeatedly fails to comply with it, courts start to lose confidence in that option. Still, the defense is emphasizing rehabilitation over punishment.
No.
And so this was not agreed, correct? There's no agreement.
How many times can the system
And the
try the
underlying
same
offense
solution?
is a state jail or
Yes.
third state jail. All right. And so, and again, sir, would you please state your name for the record?
Dory Brett Edwards.
And
for the
Mr.
defendant.
And Mr. Edwards, will you be the one that is making, that's arguing for punishment?
Yes, Your Honor.
All right. You may proceed.
Your Honor, we would like the court to take into consideration the defendant's mental health issues that is mentioned in the pre-sentence investigation and in her competency evaluation. We believe that she has had a hard time in life where she has told different medical professionals and the probation department. And we believe that she has several children who have medical conditions. There is a surgery coming up. And actually, Your Honor,
This is one of the most critical and blunt moments in the entire hearing. The judge acknowledges possible mental health issues but draws a firm line. Nothing in the report convinces him that those issues caused the criminal behavior. That distinction is key in court. Mental health can be a mitigating factor, but only if it directly impacts the defendant's actions in a meaningful way. Here, the judge is essentially saying,
filed a motion for continuance because we just found out that our client is pregnant,
especially
I think
given the
7 weeks
history
pregnant.
presented.
That's
Do
denied.
you agree?
And so we would ask the court to take consideration of her mental health issues that she has reported. We filed a motion to modify the terms and conditions of her probation when she found out she was suffering from bipolar. We did bring that to the attention of the court and the prosecutor and the probation office. And we would ask that she continue on probation.
Continue.
Those issues.
All right. Thank you. Ms. Lesniak?
My issues with Ms. Johnson are that she just keeps reoffending in ways that are
This is where the case becomes overwhelming. The judge lays out a timeline that spans decades: misdemeanors, robberies, and now over a dozen felony convictions. At this point, the courtroom isn't just looking at a single crime. It's looking at a pattern that has repeated over and over again. And patterns matter. In the eyes of the law, they signal risk, predictability, and the likelihood of reoffending. This is no longer about giving someone the benefit of the doubt. It's about protecting the public and maintaining accountability. So let me ask.
Bad decisions and putting the court in a position to have to revoke her or minimum give her some kind of inpatient treatment that it's just going to address all those. We've done, I think the status is detailed out everything that probation can do for her. I'm just not sure what's left beyond revocation.
So, Ms. Davis, other than, obviously you went through in this update for me. I'm going to go through and make sure that everyone agrees and we're all on the same page. So, Ms. Johnson, you were put on probation back in 2017, and that was a 5-year deferred probation. Is that right? It was a 3-year deferred probation. But then, while you were on probation, 2 years later, you were arrested for theft, Class B theft, and then there was a motion. Just let me talk, okay? And then there was a motion to revoke your probation filed and a warrant issued. You were taken into custody, and then you posted a bond. While you were out on that bond, so you got out on bond on a motion to revoke your probation. Then 2 months after you were out, you were arrested in Nederland for DWI, posted a bond on that. And so a new first amended motion to revoke your probation was filed. And you were sentenced to probation on that theft in December of that year. And your probation in this case was extended.
And there it is, the final decision. 6 years in prison. Not the maximum, but still a significant sentence. What's important here is that the judge followed the agreement, meaning this outcome was already negotiated within certain limits. But even within that cap, the court chose incarceration over probation. That tells you everything about how the judge evaluated the situation. The history, the repeated offenses,
for 2 years. So the motion to revoke was dismissed. You were given an opportunity to remain on probation. And then the pending DWI was just going to kind of see what happened on it, right? So then it looks like August 21st of 2022, you commit the offense of driving while intoxicated with a child under age in Chambers County, posted a bond on that. And so then a new warrant was issued for a motion to revoke your probation based on that. You were arrested on those warrants. You made a bond on those. I'm not sure why I kept giving you a bond. I obviously should have looked more closely at all of this. You came to court here May 1st, entered a plea of true to the driving while intoxicated with a child under 15, and that you failed to not become intoxicated. So then I look at your interview here with the probation department and take that into consideration with the fact that while you are out, it says here you have 5 chronically ill children. Is that correct?
I have 4.
4. One is deceased.
Well, yes, ma'am.
Okay.
Deceased.
One's deceased. So you have 4 living children that have health issues. Is that correct?
Yes, ma'am.
You have health issues. Is that correct? Mental health issues, correct?
And health issues.
And health issues. And you obviously know where children come from, right?
Yes, ma'am.
And you make the decision to get pregnant again.
It was at this moment that she knew. She fucked up.
Well, but you know how you get pregnant.
Yes, ma'am.
You know how not to get pregnant.
Hormone shot.
So the biggest problem that I have, Ms. Johnson, is that you're on probation for a crime that relates to endangering and abandoning a child. And now you've pled true to another offense that has to do with you endangering one of your children. And that's by driving while intoxicated with that child. The case that you are on probation for, I looked back, you and looks like another person, lady, were in a car, passed out with your 3-month-old in the back seat. So you didn't get a DWI because I guess you were parked and passed out in a car. It's in all likelihood you drove to where you were. So you're lucky you didn't get a DWI in that one. And here you are with another DWI. Actually, this would probably be, if they were all counted as DWIs, probably your third, because the first one probably should have been that you're on probation for. There was another one here in Jefferson and Nederland. I don't know what the outcome of that was. What's the outcome?
I think that's the one pending.
Gotcha. So are you on probation for that and there's MTRP on the DWI?
Yes.
Okay.
She has 2 pending cases in misdemeanor court.
Okay. Anyway, so I understand, and the mental health issues, I've reviewed all of those as well. The thing is, you've been given every opportunity, and probation has all kinds of opportunities and have given you to try to get those things, help with them and taken care of. But you haven't taken advantage of that. All you've done is put yourself, your children, and other people in the community at risk. At this time, I'm going to find that you entered your pleas of truth.
Also, it is as it says in the pre-sentence investigation, when we came aboard on her case, we did mention to her, as you mentioned earlier, the importance of dealing with her mental health issues. And she did start going to treatment for that. And she did, I believe, comply with paying her fees and community service.
And I see that, and I appreciate that. And those are the least of my concern. Obviously, fees and community service are important, and that's part of probation, and I'm glad you did that. But putting herself, her children, and the community at risk is what I have to look at more so.
Judge, also in the competency evaluation, I believe that doctor did say that she had certain issues that she was trying to take care of. And
I appreciate that as well. And she'll be able to do that on her own at the appropriate time. At this time, I'm going to find, Ms. Johnson, that you entered your pleas of true to counts 1 and 2 freely and voluntarily. I'm going to find those counts true. Well, hang on a second. Ms. Lesniak, did you have anything to add?
No, Your Honor, I think we can abandon counts 3 and 4. I don't think that
Okay.
is necessary for this hearing.
And
I think she did end up taking care of
I think that's right.
And Judge, her dad and her aunt, they are here to provide support, and we have informed them about what was in the pre-sentence investigation, etc.
All right. Thank you. Anything else?
No.
Ms. Davis, other than what's in your report, is there anything else for you that you would like to add? Okay, then I'm going to find sufficient evidence at this time to find you guilty and revoke your probation. I'm going to find you guilty of abandoning or endangering a child. I'm going to sentence you to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I need a certification.
This case is a clear example of how the justice system handles long-term repeat offenders. Despite prior opportunities, probation chances, and even consideration of personal struggles, the court ultimately prioritized accountability and public safety. The judge made it clear this wasn't about one mistake. It was about a lifelong pattern that never changed. The 6-year sentence reflects both punishment and the limits of the system's patience. Cases like this raise tough questions about rehabilitation versus responsibility and where the line should be drawn. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe